Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. This case is 143 days. All right. Would you mind reading what happened, please? So you were given the general order bond. Looks like you took on, it looks like we did probable cause, I'm assuming. I found probable cause at the time. We ordered you not to drive, and then I guess went AWOL. You've now made a surety bond. So, yeah, do you mind reminding me what happened, please?
On November 5th, 2025, a traffic stop was conducted on the defendant's motor vehicle after it was observed that he had expired registration. Upon contact with the defendant, the officer observed watery, bloodshot eyes and the odor of an alcoholic beverage. The defendant admitted
Driving. Oh, I mean, this is this guy. Because he just picked up a felony.
yes, it was PC.
So I guess, yeah, go forward with this one, and then I want to know what happened to the felony.
The defendant admitted to drinking a can of an empty Budweiser that was found in the passenger floorboard. Investigations were conducted. There was a 2 out of 6 on the XGN, 6 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read, and the defendant was correct, provided unacceptable samples. The defendant then consented to blood and a blood draw was conducted. And we do have the results of that blood.
You do or do not?
We do. And it came back for 0.05 ethanol as well as methamphetamine and THC.
Okay, what happened to the felony?
On March 22nd, 2025, the officer observed a vehicle displaying suspicious buyer's tag. A traffic stop was initiated. The defendant, the driver, provided a Texas driver's license, warrant checks, provided a Texas driver's license, and the warrant check revealed an outstanding warrant, which led to his arrest and now due to DWI. During the inventory search of the defendant's property at Pasadena jail, officers found a clear zip bag containing a white crystal-like substance identified as methamphetamine, which weighed 115 grams.
I'm sending you now for a drug test. I want to know what, if anything, is in your system as of right now. If you fail to go test, if you fail to come back, I'm going to revoke your bond and make it so high you will have hair falling out. Do you understand, Mr. Herrera? And the next time you miss court, likewise, your bond will reach the clouds. Do you understand? So take your seat for me. Good morning, Mr. Juarez. Sir, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 22nd, 2025, officers were dispatched at 2 a.m. to a burglary at Providence Hall at 2717 Sunbrook Drive, apartment number 411 in Harris County, Texas. The officer observed a man sleeping his head through a broken apartment window from the outside of the apartment.
Even though a 0.05 BAC is below the legal limit, when you add meth, amphetamines, and THC, the case gets a lot heavier. Do you think stacking substances should mean harsher penalties than just alcohol alone?
The complainant stated that the defendant began banging on her door and the window, trying to get inside. The complainant stated that she had no idea who the defendant was and she had never seen him before. The defendant then broke the apartment window with his right fist and appeared to be trying to get inside the apartment. The complainant stated that she was scared for her and her children, who were also inside the apartment.
And it's a mischief?
The complainant stated that the damage was $100. The officer observed the window to be broken. The defendant cut blood on his right hand from breaking the window, and there was also blood.
You were you're not charged with a series of felonies. Mr. Juarez, I'm going to find that there's sufficient probable cause to go forward with your case, and I'm now going to put an ankle monitor on you so I know where you are at all times, and I'm giving you a curfew. If I find that you're a danger to my community, I only have one place for you. Do you understand? You are not to consume alcohol or illegal drugs. I'm sending you now for a drug test. I want to know what, if anything, is in your system. If you fail to go test, if you fail to come back, I will revoke your bond. Do you understand? You're not to be in possession of any weapons. You're not to go anywhere near where these people live, work at all. Any connection, you think?
He did state on the scene that he believes that he was at a different apartment at Dunleavy and wanted his mom to let him inside.
Regardless, I'm going to send it for a text now. I want to see what, if anything, was in the system. Guys, on everything, waive the fees for everything, please. I'm going to send you for a test now. Come back. Do you understand? If you don't test, if you don't come back, it's not going to go well for you. Take a seat. You literally pled guilty not 10 days ago, and now you're back again. You now stand charged with the offense of fleeing a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 20th, 2025, officers were conducting an active patrol at the 15,300 block of Corona Del Mar Drive in Harris County, Texas, and observed a black GMC Sierra traveling at a high rate of speed in a residential neighborhood. The motor vehicle attempted to slow down once they noticed the marked patrol vehicle by hitting the brakes. At that point, the officer observed a distinctive taillight. The officer quickly turned on emergency lights and sirens to attempt a traffic stop. The motor vehicle failed to signal, making a right-hand turn, and continued driving while the officer was behind the vehicle with lights and sirens. The defendant continued driving approximately half a mile at speeds ranging from 10 to 20 miles per hour in a residential neighborhood. The defendant disregarded 2 stop signs and then
How fast in the residential neighborhood, did you say?
Sorry?
How fast?
10 to 20 miles per hour. A defendant disregarded 2 stop signs and then parked his motor vehicle in front of his residence and opened the motor vehicle door. The defendant was chased. He stated that he was coming home when asked why he did not stop and was identified by his passenger.
So, no license?
There's no license now.
Mr. Melendez, you're not allowed to drive. If you do not have a Texas driver's license and you don't have liability insurance, you're not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. I don't care what you need to do in life. If you don't have either, both, and permission from us, do not drive. Do you understand? Since the 10 days you put your arms down, since the last 10 days that you were here, what have you done to change your life? What better have you done?
I'm always going to school. Right now, I'm doing a job, AAA.
That is now a condition. You must do one of either, in school or a job. I'm going to appoint your lawyer today, and I'm going to bring you back in 2 weeks to see what you have done. If you've done nothing, it's not going to go well. Do you understand? All right. If you sign a reset, I'm going to have you take a seat in the jury box. So you're on bond for an interference and a failure to ID from November. A month later, you pick up a criminal trespass, and now you pick up a 4th case, another criminal trespass. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 17th, 2025, an officer was made aware by Fleischer apartment complex, courtesy officer that the defendant was trespassing on the property. The officer stated that he observed the defendant walking in the hallway.
An ankle monitor plus curfew is basically house arrest without the bars. What do you think, fair compromise, or should repeat offenders like this head straight to jail?
Of the property, and due to previous encounters, knew the defendant to have a criminal trespass warning from the property. Defendant was detained.
The defendant has had numerous criminal trespass warnings from the location and a recent arrest for criminal trespass due to being on the location. He was identified.
Was this the same as the prior one?
Same location.
Same location?
You're not liable to speak for
No.
Well,
What I'm going to do is I'm going to put an ankle monitor on you so I know where you are at all times. You're not to consume alcohol or illegal drugs, and I'm also giving you a curfew. If I find that you're out in the middle of the night, if I find that you go anywhere near this, I'm going to take all your bonds now, and I will triple, quadruple. Do you understand?
Right.
I'm going to protect my city at all costs. You now have 4 open cases. You have made bond on those cases. If they give you a PR bond, I'm telling you now, you pick up the 5th case. I'm going to make your bond so high you'll have teeth for it. Do you understand?
so,
Tell me about the interference, please.
Yes, Judge. So on November 26, 2024, an officer heard a verbal disturbance in a parking lot while patrolling on foot in an apartment complex. The officer made contact with the defendant and a female. The officer attempted to identify the defendant, who refused to identify himself, stated, "I'm not identifying myself." The officer
Same complex.
Please check.
Stop.
Yes, Your Honor.
I don't want you to go within 1,000 feet of this apartment complex. Do you understand? I have a monitor that I'm going to put on your ankle today. If it dings anywhere near there, I don't care what your excuse is. It's not going to go well for you. Your cases are now from November of 24. It is way too much drama for me. So you will get a lawyer today, and in 30 days, discovery complete on the cases from 24. It's way too much drama. I'm ready to set these off for trial.
Summary is complete on interference warrant.
Very good.
Summary is also complete for the previous criminal justice.
Get ready. I'm fast tracking this trial, 30 days.
Yep.
So I'm gonna put him a lawyer today. I'm gonna have him take a seat in the jury box, have him meet with the lawyer. 30 days to get set for trial. You're not to consume alcohol, illegal drugs, and prescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, it won't go well for you. You understand? All right, come on. Good morning, Mr. Nguyen. Speak English. Mr. Nguyen, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 21st, 2025, an officer was traveling southbound on Grand Line. The officer was driving 80 miles per hour at 75 miles per hour zone. He then witnessed the defendant operating a motor vehicle pass him from the improved shoulder. The officer followed the defendant and witnessed the defendant change lanes when unsafe, drive on the shoulder, follow other vehicles too closely, drive without lights when required, and pass on a no passing zone disregarding the safety alarm.
Okay. Mr. Nguyen, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? The license. As a condition of your bond, I'm ordering you not to drive like this anymore. If I find that you do, I will revoke your bond, put you in jail. Do you understand?
His driver's license is eligible.
You're not allowed to drive unless you have valid liability insurance as well as a Texas driver license. Do you have the ability to hire a lawyer, Mr. Nguyen? How old are you? Okay. We'll provide you a lawyer today. You will be signing bond conditions. I'm telling you now, jail sucks. At 18, if you end up going to jail, they will have a field day with you. Do you understand? I'm not asking much, but if I find that you make my streets unsafe in any way, it really will not go well for you. Okay? I'll have you sign a receipt. We'll have you. Okay. Deputy Miranda's going to detect you where to go. No, don't worry about it. Do not leave until you sign our bond conditions. Do you mind following? No reckless driving, racing, street takeovers, donuts, etc. Good morning, sir. So you're charged with the offense of falsifying drug test results. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 22nd, 2025, an officer was assigned to the Harris County Toll Road Authority, DWI Task Force, observed a vehicle traveling 87 miles per hour and 65 miles per hour. The officer observed a traffic stop was initiated, and the officer observed a strong odor of marijuana. The defendant stated he personally smoked marijuana earlier that day. The defendant offered to allow the officer to search his vehicle for marijuana. The officer conducted a probable cause search of the vehicle and located a firearm. The officer also found a liquor flask.
The ignition interlock is a breathalyzer built into your car, and you can't start the engine until you blow clean. Would this cut down drunk driving in your city, or do people always find a workaround?
Sized opaque plastic bottle in the glove box, with a temperature sensing strip on the top containing a yellow liquid. The defendant stated he purchased the bottle so that he would not fail a drug test to get a job.
Any open cases?
No open cases, Your Honor.
All right, Mr. Onikidi, I'm going to find that there's sufficient probable cause to go forward with the case. Sir, do you have the ability to hire a lawyer?
I actually have a lawyer who's present tonight.
You do have a lawyer. Let me see if any documents have been filed. Do you guys see anything? Are they going to? You've hired them?
Yeah, I did hire them a couple of days ago.
They told you they would be here?
Cynthia.
Who is it?
He's from Gilligan. I don't know.
Say Gilligan? Yes, let's do this. I'm not going to put any conditions on your bond. Well, hold on a second. Does he have a license?
He does. It is eligible, Your Honor.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I guess I'll have you sign a receipt now. We'll have you take a seat. It's still kind of early. We'll wait to see if they come. Do you have a phone number? Maybe you can go call them, see if they'll come, and then you can address your, but don't leave until we excuse you. Okay? All right, please.
Joseph, big one commission?
Yeah. You are Victor Ortiz. Mr. Ortiz, you're charged with driving while intoxicated. Second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed.
On March 20th, 2025, an officer observed a vehicle traveling with its rear license plate lamp out, making the license plate unreadable. A traffic stop was initiated. The officer made contact with the defendant, the driver, and the officer observed the strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, stumbling, and the defendant used the car for support. During an inventory search of the motor vehicle, the officer located 4 open containers, 2 empty and brown bags full to the touch, 1 half empty, and 1 freshly open. All 4 were full to the touch, and they were 4 Logos. The defendant denied drinking the alcoholic beverages and admitted to being an alcoholic, having a drinking problem, but he stated that he did not have any idea how many alcoholic beverages got into the motor vehicle. Both of his teas were refused. The defendant was read the DIC and declined to provide a specimen. The defendant was a resident of Bloodworth, was signed and executed.
Please, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive. I don't care what's going on in your life, and you are signing an affidavit with me promising me you're not going to drive. If I find that you do, I can have a contempt hearing. Every time you drive, it's an offense punishable by up to 6 months in jail and a $500 fine. Do you understand? You will now get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you fail to blow into the device, if you consume alcohol, if you consume illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? If you have a problem with drugs or alcohol, you better address it. Now is the time for you to address it. Because if you don't, and it becomes a problem, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand? I am now also placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have an ignition interlock on it. We send this notice to DPS so that everybody in the entire world or I'm sorry, all officers in in Texas know that if you're driving, you must have an interlock, and if you don't, they will put you in jail.
Sure.
No alcohol, drugs, random testing, and a portable device. You have the ability to hire a lawyer, Mr. Ortiz.
No, yeah.
Have you fill out an application? I'll take a look to see whether you qualify. I need to know everything about you. How much money you have at the bank, what you do for a living, what kind of car you drive, and then I'll take a look to see whether you qualify. Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria. You'll reach out for your bond conditions, and after that, we'll take a look to see whether you qualify. Mr. Smith, you're charged with 2 cases. You're charged with possession of marijuana. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the weed case, you're facing up to 6 months in jail and a $2,000 fine. If we're going to do probable cause, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, the officer had conducted a traffic stop for expired registration at 567 South Mason Road in Harris County, Texas. The co-defendant was taken into custody for 5 active warrants. The driver was asked to take a bag of him containing his personal. Inside the bag, the officer claimed a small white plastic bag containing multicolored chocolate pills known to be ecstasy and Xanax. The co-defendant claimed ownership of the pills. Probable cause search was conducted and officers located a handgun with ammunition located behind the driver's seat on the floor of the vehicle, a baby bottle containing promethazine cough syrup, and a cylindrical container of marijuana. The total weight of the ecstasy pills was 8.4 grams. The weight of the Xanax pills was 118.2 grams. The weight of the marijuana was 0.05 ounces. The weight of the promethazine cough syrup was 5.19 ounces. The defendant, the passenger in the vehicle, claimed to be the owner of the marijuana and the gun and stated that the gun fell out of his pocket and landed behind the driver's seat.
What about magazine and all that? Who's was there a second gun?
No, there was just one firearm, Your Honor.
Did they charge the other gentleman?
Yes.
So how can they charge him with it?
So he took ownership of the marijuana and the firearm. The defendant. Yes. The co-defendant took ownership of the ecstasy.
You said that the co-defendant said the gun fell out of his pocket.
No, the defendant said that.
Gotcha. Okay. All right. Mr. Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? I'm also ordering you. Can you run his light? He's the driver, right?
No, he was the passenger, Your Honor.
All right. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? Do you have the ability to hire a lawyer, sir? Also, I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Are you working at this time?
Yes, sir.
Okay. I need to know everything about you, and I'll take a look to see whether you qualify. Do not leave until you sign our bond conditions.
Yes.
All right. So no contact with the co-defendant, no weapons.
Yes, Your Honor.